lawyers, pursue the opponent clients also sometime when you go for settlement. So it is very important that you use a very good vocabulary. Now vocabulary does not come in a day. You have to work on it. Today I have taken out 10 important words which I will share in the group later on, or Vandana madam will share, or Lalita will share. So always remember, just wait for some time to improve your vocabulary. And vocabulary doesn't mean speaking very important good English words, but vocabulary means you start with your good words. It should be clarity, it should have some impact on the other side. And I have heard from a few friends that your words should be ornamental. Now, ornamental does not mean that you should use the flowery language, but then it shouldn't be used like just like that. False and true are very regular words. But here we will start with one first word, that is veracity. Now, veracity is bona fide. Some call it veracity, some call it veracity. The veracity is first word, write down, and I will share it later in the group. Just understand, it's a bona fide. How do we use the word veracity? I doubt on the veracity of the witness. See, in the court, you will always find people who will say, this witness is not speaking the truth. No, I doubt on the veracity of the witness. So, उसकी जो सत्यता है, उसकी जो bona fides है, I doubt. Now, I want to question to test his veracity. This can be another example. When you tell before the court, you are standing before the court and you are saying something. When you say this witness was speaking truth, or you say I want to cross-examine this person, then you have to use the words. I want to question question to test his veracity. I want to question his veracity. Now, next word, which is very popular nowadays, there is sedition. If you speak anything against government, it is called bringing hatred against the government. Now, sedition charges, that is in Hindi में हम लोग बोलेंगे राजद्रोह, यानी जो state government है, जो central government है, we have federal system in our country. At a state level we have state government, and the whole country is governed by the central government. So whatever you speak against the government and you are bringing a hatred to the government, it will be sedition charges. For this, kindly see section 124A of Indian Penal Code. Section 124 of A of Indian Penal Code is very important. If you read, you will. It is defined what is Rajdroh. So sedition is the very important word, and you should know this. Whatever you are speaking, sometimes there are the people who come before the us and tell the government is not doing anything, or government is not working properly. You can always say, see, if you speak, you can't speak against the President of India. You can't speak against the government. They are immune. There is a reputation, and it can be a defamation. See, defamation is under section 500 of Indian Penal Code. And when you speak against the government, it can be also against the, it will be called sedition charges. Now, next word is ever. Ever is a very small word, but then we normally use. I will use in the petitions of the matrimonial disputes. Sir, I have made averments about this in petition. I have made, or the judge will ask you, have you made averment in the petition? What you are saying before the court. So averment का मतलब होता है state, to declare. So yes, I have declared in the petition. So always these facts are true and correct. The averments made herein are true and correct. So these averments are also very important. So the third word is ever. Now fourth word is substantiate. That is to give evidence. How will you substantiate? It is allegation. Now in a matrimonial dispute or anything, on criminal matters, there are charges against the accused. In matrimonial disputes also you put allegation. So how do you prove? That is by taking evidence. And how do you take evidence? By cross-examination or by putting an affidavit of evidence. So the word is substantiate. I will substantiate it by giving these evidence. Okay. Now next is elicit. Elicit is to manage to get information. Sir, I will get an elicit. I will elicit the information from this witness. The next word is elicit. I will get the information. So this is the English meaning is to manage to get that information. But it is elicited in the cross-examination. So whenever you are speaking before the court, you are saying something and you are putting your words. Then you have to say, sir, I have elicited this information from the witness in the cross examination. Now, next word is envisages. Now, envisages is some people also speak envisages. That is this word, you know how visual, how we pronounce visual, visual. But here also envisages also you can call, or you can call envisages. Now, envisage is to form an opinion, to form an idea, to imagine. Sir, this is envisage. Now, see, there is a government scheme, which is the government scheme is also envisage. जो आया नहीं है, scheme is going to come. This is envisage. मतलब ये आने वाला है. Whatever you are imagining or to create, और जिसे परिकल्पित, मतलब आप सोच रहे हो कि ऐसा होने वाला है. So this is envisage. He will not speak the truth. Now next word is little difficult. Unequivocally. And unequivocally is apparent. Sometimes say, sir, there is glaring inconsistencies. Matlab, this witness is speaking at one level, he is speaking this, at second level, he is speaking this, at third level, he is speaking this. So unequivocally, that is apparent, glaring. अभी लिविंग नो डाउट, तो अनइक्विवोकली ग्लैरिंग मतलब अपरेंट आपको फेस पे दिख रहा है कि अनइक्विवोकली में मतलब क्लियर है, क्लैरिटी है कि आई विल गिव एन एग्जांपल. The party to the suit has not unequivocally set up adverse possession. Now here is a case of adverse possession. एक छोटा सा केस था जिसमें वो पार्टी बोलती है मैं बहुत सालों से यहाँ पर रह रही हूँ. But then they should provide a proof by substantiating giving some documents, which they are not giving. So the party to the suit has not unequivocally set up an adverse position. To speak these words requires lot of practice. So if you try it, it will be easier. So if you have to be prepared in बोलते हैं advance में you have to prepare when you want to speak these words, and slowly with practice you can also use these words. So unequivocally you will find this word in almost few judgments. Almost मतलब if you take out 100 judgments, out of that 50 judgments you will find these words. So these are regular words used in the legal vocabulary. So unequivocally, leaving no doubt, with clothing. Unequivocally it has been proved. Next is very simple word, refute. You all have heard refuse. Now this word refute means to deny. I am refuting all the charges leveled by the respondent. This way we are speaking. Refuse nahi bolte, and refuting. The charges are refute. Refute means deny. R-U-F-U-T. Next is also very popular word, squarely, that is directly. Now this is very popular words. Whenever you will go to High Court and you sit down for some time, you will regularly hear this word, squarely. This applies directly. Now I will, sir, I am giving this case of Mamta Jaiswal versus Rajesh Jaiswal, which is squarely applied to the present proceeding of my present case. See, understand, squarely is directly applying to my. So whatever is directly, this is mostly used when we are comparing two situations. So we are saying such situation is the same. Now, the principle laid down by Supreme Court in this case applies directly to the present proceedings. This way also you can use these words. Next is also very popular word which is used in matrimonial dispute, that is vindictive. That is uska meaning hota hai pratishodh ya badla lena. Now here, sir, she has filed this case out of vindictiveness, or the attitude of the complainant is vindictive. It is a person who wants to hurt another person and is thinking that the person hurt me, that's why I want to hurt it. The vindictive nature is mostly used in the matrimonial disputes. So these were the local vocabulary. If you can use and you remember these words by making practice again and again, so definitely it will help you in the future. Now, I'll discuss today two sections of Civil Procedure Code. And these sections are very important. If somebody is having Civil Procedure Code at hand, they can open. And if it is not available, then also it's fine. Small two sections. Now, section 24 of Civil Procedure Code deals with the transfer petitions, transfer of suits. Civil means it's totally civil, no criminal matters. Now in civil matters, always remember, you may file a case as I stay in Maharashtra, I'll tell you, I may file a case in Panvel court, and there is somebody who is in Satara. Now, Panvel and Satara, both these places are in Maharashtra. Now, some person, petitioner or respondent, they want to get, the petitioner, of course, has filed a case in the Panvel, and the respondent wants to get it transferred. It is Satara. Which court they will apply? Because it is in the same state of Maharashtra, and they have to approach the Bombay High Court. So when they approach Bombay High Court, as it is between the same state, this is the High Court of the Bombay will have an authority under section 24 of Civil Procedure Code to get it transferred. So always remember 24 CPC has to be used for civil matters to be transferred in the Bombay High Court. Now next is section 25. Suppose I file a case at Mumbai and there is another client, the client against whom I have filed is staying at Delhi or Jaipur. So it is two different states. One is Maharashtra, another is Rajasthan. So now the matter is between two states. So what will happen when the matter is between two states? You have to approach the Supreme Court because neither of the high courts, that is High Court of the Rajasthan or the High Court of the Mumbai, that is a Bombay High Court we call, both cannot entertain because they cannot have, because both the people are staying in different high courts. So there you have to approach the Supreme Court of India, and Supreme Court you can approach under section 25 Civil Procedure Code. 25% matters in the Supreme Courts is about pendency of the under section 25, that is mostly matrimonial disputes, because nowadays the wife is residing at Rajasthan, husband is residing at Mumbai or all over. So we have so many states and so many union territories, so there will be cases pending here and there. So wife may file a domestic violence case at Delhi and the husband may be staying at somewhere else. So anybody, the husband, it is gender neutral, these sections, anybody, those who are parties to the list. Now see, I have used the word list, LIS. Now what is the meaning of LIS? List means case. तो आप केस को लिस्ट भी पुकारते हो, तो ये सब लीगल वोकेबुलरी है. तो आपको सब जितना जानकारी होगा, जितना इंफॉर्मेशन होगा, it will be very useful and you will be giving an impression to the court that you have been reading good judgments and you have good knowledge about this. So always remember that it is very important that you read the judgments. I've been saying, I said yesterday also that in these 10 days I will give 10 judgments. If you can read at home whenever you have time, it will definitely come to your mind when you are speaking before the court. So how these words can come to your mind or how you will learn, you have to do one thing. You can keep a notebook like this and you can note down all these words. Make an English translation of the same and also the language, Hindi, Marathi, Gujarati, whatever language suitable to you. So completely this, the meaning of these words will go in your head and in mind, and you can use these words in future. And once you repeat these words 3-4 times, it will completely in your subconscious mind and automatically will be using. See, when we are in school, we are using so many words and we hear also from our teachers. And unconsciously, subconsciously, we put this in our mind. So always remember that you can use these words, but provided you practice these words. Now, third is section 21-25, we have already checked. Now, one more judgment, very important celebrated judgment, though it is of the Madhya Pradesh High Court. It has been cited many times. I will try to share it. Just a minute. Now see, I'm sharing it through Indian Canon. Now if you read Upper, it cites two document and cited by 23 documents. See the third line in the title. Cited 23 documents. So it's now let's go to this is Madhya Pradesh High Court judgment. Mamta Jaiswal versus Rajesh Jaiswal, year 2000. Now the bench is of Justice Chitre. He expired few days back. The language of this judgment is very flowery and ornamental. Uh, this first, second, third few paras up to 4, 5. It is discussing the section 24 and 26 and also the facts of the case. But let's go to the para 6. I'll read the para 6 and you will find so many words into it. In view of this, question arises as to what way section 24 of the act has to be interpreted. Now here section 24 is about Hindu marriages. Whether a spouse who has a capacity of earning but chooses to remain idle should be permitted to saddle other spouses with his or her expenditure. Look at the wordings. Whether such spouse should be permitted to get pendant light alimony. Pendant light alimony का मतलब है जब when case is pending, you are asking alimony at higher rate from other spouse in such condition. According to me, section 24 has been enacted for the purpose of providing a monetary assistance to such spouse who is incapable of supporting himself or herself. Now see, section 24 of Hindu Marriage Act. It is not only for ladies, it is also for the male. It's gender neutral. See, supporting himself or herself in spite of sincere efforts made by him or herself. So section 24 applies to both the people, whether husband or wife. Anybody can make an application under it, made by him or herself. A spouse who is well qualified to get the service immediately with less efforts is not expected to remain idle to squeeze out milk out the other spouse by relieving him of his or her own purse by a cut in the nature of pendant light alimony. The law does not expect the increasing number of such idle persons who by remaining in the arena of legal battles try to squeeze out the adversary by implementing the provisions of law suitable to their purpose. In the present case, Mamta Jaiswal is a well qualified woman possessing qualification like MSc, MC, MEd till 1994. She was serving in Ghulam Nabi Azad Education College. It impliedly means that she was possessing sufficient experience. How such a lady can remain without service? It really puts a big question, which is to be answered by Mamta Jaiswal with sufficient cogent evidence. Mostly cogent evidence हम लोग word use करते हैं. The cogent and believable evidence by proving that in spite of sufficient efforts made by her, she was not able to get service and therefore she is unable to support herself. A lady who is fighting matrimonial petition filed for divorce cannot be permitted to sit idle and to put her burden on the husband for demanding pendant light alimony from him during pendency of such matrimonial petition. Section 24 is not meant for creating an army of such idle persons. Look at the wordings and the sentence formation. Who would be sitting idle waiting for a dole to be awarded by her husband who has got a grievance against her and who has gone to the court for seeking a relief against her? The case may be vice versa also. See, he has already clarified. The case may be vice versa also. हो सकता है कि husband बोलता है मैं काम नहीं करूँगा and he can make an application. I lost my job. If a husband well qualified, sufficient enough to earn, sit idle and puts his burden on the wife and waits for a dole to be awarded by remaining entangled in litigation, this is also not permissible. The law does not help indolence as well as idols. So also does not want an army of self-made lazy idols. Everyone has to earn for the purpose of maintenance of himself or herself, at least has to make a sincere effort in that direction. If this criteria is not applied, if this attitude is not adopted, there would be a tendency growing among such litigants to prolong such litigation and to milk out the adversary who happens to be spouse, once dear but far away after an emerging of litigation. If such army is permitted to remain in existence, there would be no sincere efforts of amicable settlements because the lazy spouse would be very happy to fight and frustrate the efforts of amicable settlement because he would be reaping the money in the nature of pendant light alimony and would prefer to be happy in remaining idle and not bothering himself or herself for any activity to support and maintain himself or herself. that cannot be treated to be a goal of section 24. It is indirectly against healthiness of the society. It has enacted for needy persons who, in spite of sincere efforts and sufficient effort, are unable to support and maintain themselves and required to fight out the litigation, partizing their hard-earned income by toiling working hours. Now look at this. Now here when we read this judgment, and especially para 6, I would request all of you to read the complete judgment. I'll stop sharing this. Now when you read this judgment, always remember one thing. You not only get the importance about the important words or the ratio laid down, you also get new words. We also, when I read this para, you read section 24 of Hindu Marriage Act. Now what is section 24 of Hindu Marriage Act? It says that a husband or a wife during the pendency of the case can always apply for the maintenance. See, it is gender neutral. And what is section 26? Section 26 बच्चों के maintenance के लिए. It is for children maintenance. Some lawyers and some of my colleagues also, they apply section 24 for children also. See, it does speak about, but then section 26 is very important. Section 24 is only for the maintenance of the spouses, मतलब husband और wife. जब आप section 26 भी apply करेंगे तो judge will know कि why she is applying section 26. So you should say custody and maintenance of the children. It is applies to custody and maintenance. So maintenance of the children. So you apply with combined section 24 and section 26. Whenever you are filing a maintenance for the children and the wife, so you can apply both these sections. So see, by reading, we got good words of vocabulary. We also got good words about the legal good words, vocabulary ka. Secondly, the English is also very, I would say, ornamental. If these words are used in your writing while replying. Now suppose you, how you can use this judgment? You are for the husband and wife has made an application. She is very educated like Mamta Jaiswal. In those cases, आप उसका जो education background है वो आपके application में ला सकते हो. And same time you can also apply. You can apply this judgment, the words of this judgment. And if you apply these words of this judgment, trust me, it will help you. That, see, what is the court saying? That section 24 is not evolved because we want to create an army of a woman or also a man कि just मतलब pendant light जब petition pending है court में petition डाल दी तो he will keep on milking out the maintenance from the other spouse. So it is not for that purpose. So please go and try, always read judgment, and whenever you are drafting, try to read judgment. This will help you. So this was what all about today's internship. We have 30 people. So anybody is having question can start. I will start. And first, kindly write your name in the chat box. So Vandana can announce. You can unmute yourself now.
Any participants have any question, please write in the chat box.
You can write your name, the Vandana can announce, so we can take one by one. Vartika, you can. Vartika, you have to unmute yourself.
Good afternoon, ma'am.
Yes, yes.
Yes, ma'am. Good afternoon, ma'am.
Good afternoon.
Ma'am, my question is that, yes, ma'am. Ma'am, my question is that there are many provisions regarding maintenance, such as under section 125 of CRPC and some other personal laws. Ma'am, if a woman want to claim maintenance from her husband, and then in which of them she can claim maintenance?
Can you repeat your question?
Yes, ma'am. Ma'am, there are many provisions regarding maintenance. And if
I got your question. See, there are so many laws. I got your question. See, if there is already a case pending, under Hindu Marriage Act, either filed by the wife or the husband. She can go, if she, I'm supposing she's a Hindu woman here, right? Then she can go for the section 24. Okay? And for our children for section 26, that is Hindu Marriage Act. That is before family code.
Yes.
And if there is no family code, then it will be before the if it is a remote village somewhere, there will not be a family code. Then there is senior division. Okay. Then for maintenance, there is 125 CRPC. One of our colleague Vishnu has discussed that yesterday. 125 CRPC also a married woman can file. Now there is one more act, Domestic Violence Act also. Under that also it can be filed for maintenance. Then Hindu Adoption and Maintenance Act. There are so many laws where we can file. For Muslim also there is a, but mostly Muslim women, they goes for domestic violence. There is a dissolution of Muslim Marriage Act also. But many people doesn't know this, and then they don't apply. Under dissolution of Muslim Marriage Act, you can go to family court for filing divorce for that lady, and same grounds are given which is given to Hindu women. Okay.
Okay, ma'am. Ma'am, one more question.
Please.
Ma'am, if wife want to claim maintenance from her husband, and her husband have no source of income, then what can he do?
See, wife wants to claim the maintenance from the husband. Husband no source of income. As a prudent lawyer, you should never say this. The husband is not earning. You have already said to the court he is not earning. So you should always ask, say that he was working and now he's not working. Let him come and say before the court, right? If you only yourself say that he's not working, what will happen? So what, and let him say, and then I'm not working now, then you have to bring out it what he was in the past working. Like in Mamta Jaiswal, she was working and earning sufficiently. Never say that he's not working. A lot of people make this mistake, that my husband is not working. If you put up this before the court, from where the court is going to award? Okay. So these are tricks of the trade.
Next is Soumya Pachori.
Okay, ma'am. Thank you.
Soumya, video on कर दीजिए please.
Good afternoon, ma'am.
Good afternoon.
My name is Soumya Pachori. And ma'am, could you please explain what is a special leave petition?
Special leave petition is filed before the Supreme Court. Yesterday you were there, Soumya?
Yes, ma'am, I was.
I will tell you why. Yesterday, if you read hear my yesterday's speech, it was regarding if suppose you file an anticipatory bail before the session court, it is rejected. Then you go to High Court. Again, it is rejected. Then where do you go? You go to Supreme Court. Now, Supreme Court, there is no anticipatory bail provision. So, you have to read Article 136. That is special leave petition. So, mostly all the orders of the High Court or any court, below courts, are challenged by way of special leave petition under Article 136. Okay?
Okay, ma'am. And one more question, ma'am. What is adverse possession?
Adverse possession is, suppose I am staying in this house without any title for 12 long years. There are 12, 30, there are different criteria for that. I'm giving 12 years. Then somebody comes and says, this is my house. He is actual owner. But 12 years he did not take any objection when I was staying. He never asked that. Then I am entitled to not to be dispossessed from this place. By way of adverse possession, I am entitled to stay here, continue. And if I have to remove, I have to be removed by due process of law, by going to the court.
Okay, ma'am. Thank you.
Roshan has written the question in the chat box.
आप वीडियो ऑन करके पूछे, इंटर्नशिप में अगर हम लोग एक दूसरे को देखेंगे नहीं तो कब देखेंगे?
Good afternoon, ma'am. My name is Roshan Desai.
Yes, Roshan.
I have one question. I'm audible to you?
Audible
Yes,
है, आप थोड़ा जोर से बोलिए,
so I
please.
have a question like, Yeah. So my question is, wife can claim maintenance under 125 CRPC and under the
Yes.
Hindu Marriage Act simultaneously?
Yes, she can claim because जो Hindu Marriage Act है ना section 24 का, that is interim maintenance. Always remember, it is not permanent
Okay.
alimony. Permanent alimony का section है 25. Hindu Marriage Act का, that also you can know now. So see, when we discuss, so many questions comes. So he, she or he can claim, both can, it is gender neutral. Section 24 में, in the Hindu Marriage Act, in the family code, or before the senior division in the family code. But when this matter goes, now you are asking 125 whether she, in 125 she can claim, but now your question, can she claim both the places? Yes, she can. Also
Yes,
she
yes,
can claim under
yes.
domestic violence, but the amount awarded in one petition will be considered while they are awarding in another petition. Suppose here it is 3000 already granted to her, and she is asking again, and the court, another court, the court where the 125 petition or application is pending, it is finding it that she has already got sufficient, it may not award it. You have to bring, as a lawyer of the husband, you have to bring it in front of the court. She has already been awarded the maintenance by under section 24, and that is sufficient. And if the court at all awards, it will be in consideration of what is has been awarded in section 24. तो दोनों का कंबाइन होगा. It will not be 3000 इधर भी होगा and 3000 वहां भी होगा. Okay, it will be considered equally.
Okay. Thank you, ma'am. Got it.
Amisha,
Next
you
is
have a question. Amisha, you have to keep your video on. It is
Good
sometimes.
afternoon, ma'am.
Good
I have a bit of a difficulty with my camera.
Okay, no problem. It is sometimes difficult to analyze ratio decidency and obiter dicta while reading a judgment. Could you explain it? Okay. Now, ratio decidency and obiter dicta बहुत important part है. But obiter dicta, I'll tell you in a nutshell. I'll try to take it tomorrow if you are attending it. तो रेशियो डेसिडेंसी मतलब वो उसका रेशियो है ना, कंटिन्यू चलेगा. इट विल ऑलवेज बी रिमेम्बर्ड. और ऑबिटर डिक्टा कभी कभी जज ऐसे ही बात कर लेता है, मतलब ऐसे ही बात कर, इन द सेंस द कोर्ट डिस्कसेस मेनी अदर थिंग्स इन द जजमेंट which is not important, which will not be related to the future cases. But ratio decidency you have to continuously apply. So there is a judgment. If you take out a judgment, from which principle will be applied, like principle will be applied to all the cases. So there is a possibility that something in judgment decided about the Mamtas, that how much money will be awarded to the child. Now see, child's maintenance can be awarded 500 in one case and another case 5000. So it depends on the particular case. Now this is called obiter dicta. Court may decide the child is only 6 years, he is only going to this school, he is not doing any of this extracurricular activity. So he or the child may not require this much maintenance. So this cannot be used. So this is called obiter dicta. And what is ratio decidency? Wife cannot be sit to idle because she is highly educated. She cannot be allowed to sit idle. So this is now ratio decidency. Now your question, it is sometimes difficult to analyze. Dear, you will be able to take out this, but with some time you have to go on reading the judgments, and slowly you will understand ki what is obiter dicta. Like I said, the maintenance awarded, how much maintenance awarded in Mamta Jaiswal is obiter dicta. But a wife cannot be allowed, a highly educated wife cannot be allowed to sit idle. Is a ratio decidency. Okay?
Yes, ma'am. Thank you.
Thank you. Anybody? We have 1 minute. So anybody now having question? I'll hand over to Vandana now. Vandana, you can unmute yourself.
Anyone has any questions? Ma'am, then we can end the session today.
Okay, it's a 1 minute only. You can say what vote of time.
Ma'am, we are grateful to you for taking out time and for enriching us with your words, knowledge, and wisdom. This will definitely be very helpful for the upcoming lawyers. And at last, we thank all the attendees for being cooperative during this session. Be there tomorrow at 2:30 p.m. Thank you all.
Thank you.
Thank you, ma'am.
Bye.
Thank you, ma'am.
Thank you.